Tonight, our topic is State Repackages Woyome case. Of course, Repackages Woyome has been on our lips for some time now, and every time we mention his name, we also mention a huge sum of money, 51 million Ghana cedis, and we describe it with one word: Allah Martin Hamidu, actually, Gargantuan. And then it goes on, and all these matches were backs and forths, and all the surrounding circumstances around it. But today, we all know that the leading newspaper in this country had a leading article that said that Repackages Woyome trial to begin today, and many of the news houses actually said so as well. And so interest was heightened, and we went to court. Many did, only to be told that the Attorney General had entered a nolle prosequi. We will get our guest tonight to explain to us what that means, and so we all come to terms with it. Nolle prosequi, as well, Justice Ayiti of the Supreme Court actually says it's easier to pronounce the Latin words when you speak Ga, because qui is qui, and you don't have to twist it around the way people have done today in the media. But basically, that's the issue. Many are saying that they were quite surprised by it. They were told that there was quite a bit of drama in court. Mr. Repackages Woyome, after really he had been discharged, stayed in the court for some time. Many said he also knew that somehow he was going to be rearrested, and that actually did happen. Fresh charges brought against him. We also get some detail with regard to the fresh charges, and get some education completely generally about the matters and why really there was a need to do that. Could they have gone ahead without it? Some of the questions I have been asked personally. Some say, okay, so if they didn't want those two, why didn't they just cancel it on the charge sheet and move on and all? We'll get some education on this matter. In the studio with us on my immediate left, James Agalga is a lawyer. He's also the aspiring member of parliament for Busa North constituency. Thank you for coming, sir.
Thank you. And
from the far end of the table, Kisi Ejabeng is a lecturer in criminal law at the Faculty of Law, University of Ghana, Legon. He is also a practicing lawyer, same as James Agalga. And also, sometime during the show, we hope to be joined by Augustine Obuo. He's a former prosecutor, to also give us some perspectives based on his interest and experience with regard to prosecutions in this country. Your views are absolutely important to us, so send them to 1760 by text across all mobile networks. Each text message costs 30 pesos. If you're on Facebook, facebook.com/multi-TV PM Express is the address at which you can reach us. Let me begin from the far end of the table, purposely for education purposes, as it were, some tutorial in a quick fashion, and ask Kisi, what happened today in court? I mean, basically, that money said the trial was to begin. It did not begin, and then all the news we heard about a nolle prosequi, and then all of a sudden new charges being brought. What do all of that mean?
Well, nolle prosequi means an indication of an intention on the part of the prosecution not to proceed with the charges as laid.
Okay.
Indeed, it can translate to mean do not prosecute. So it's just an information to the court that we are not really interested in the charges as laid before you. Of course, by law, the prosecutor or the prosecution is not required to explain normally why it is entering a nolle prosequi. Then afterwards, the legal effect of that is really nothing.
Okay.
It does not amount to an acquittal. It does not amount to a discharge. That is to say, the case can always bring up fresh charges against you in respect of the same transaction. So what transpired in court today, I believe that is what the prosecution was trying to achieve. Indeed, as we are told, he was rearrested and fresh charges preferred against him. As to whether the charge sheets could not have just been cancelled and the fresh charges substituted, really it's not here or there. It's a matter of style.
Okay. Okay, I see. Interesting. Let me also get some initial comments from James on the near side of the table. So James, really, again, what we are asking, why all the drama 5 months down the road or so since we started? Really, is this something? Is it strange, or is it just in the normal course of events?
Well, thank you. I think that largely I agree with Kisi on his submission on what nolle prosequi is all about. It is a statement of intent on the part of the prosecuting officer that they do not wish to continue with the prosecution of a case, be it civil or criminal. At the end of the day, the effect of the entry of a nolle prosequi really does not absolve the, you know, as it were, the accused of the, you know, from further prosecution. What it enables the state to do is to repackage themselves, and if they think that there are fresh charges which can be preferred, they are perfectly entitled to do so. And as you would recall, today Woyome was discharged and immediately rearrested and fresh charges preferred against him. I think that there is nothing strange or unusual about the procedure the Attorney General invoked. I mean, if you look at our laws, Section 54 of the Criminal Procedure and Juvenile Justice Act, Act 30, clearly the Attorney General has that power. The discretion is vested in the Attorney General, and nobody can question the Attorney General, you know, as to why he elects to exercise, I mean, the power to enter a nolle prosequi in the course of prosecuting a case. What is interesting about the Woyome case is that when Woyome and the others were charged, the state continued to investigate the matter.
Okay.
Because it was a matter that was of, I mean, national interest. A lot of money was lost to the state. So many former government officials were actually invited to the CID. They were questioned, they were interrogated, and I believe in the process the state has uncovered a lot of evidence. Now, in our criminal jurisprudence, the essence of prosecution is not to secure convictions at all cost. The essence of prosecution is to ensure that justice is done. Whether justice is done to the complainant in a given case or the accused or not, that is the bottom line. And so I think that, I mean, in the course of time, the Attorney General may have realized that it is in the interest of justice to enter a nolle prosequi, discharge some of the accused persons, and charge one of them or prefer fresh charges against Woyome. What is likely to happen is that the Attorney General may elect to use some of those former accused persons as prosecution witnesses, if that would serve the interest of justice. I mean, I'm speculating. I don't work in the Attorney General's department. I'm not saying that that is what the Attorney General intends to do. But these are some of the things the Attorney General could possibly be, I mean, intending to do. So really, there's nothing wrong with the exercise of that discretion. It is not new to, I mean, our legal system. Time without number, the Attorney General, I mean, has exercised that function. I believe in the former President Kufuor's administration, the Attorney General exercised that power. I mean, if my memory serves me right, in the case involving Nana Konadu, at the point proceedings were terminated, I believe a nolle prosequi was entered. So this is nothing, there's nothing new about what has happened.
Okay, nothing new about what has happened. But Kisi, what many again will be asking is, in all that has happened, all the fanfare, as so to speak, was it just for purposes of, as it were, buying time, since the judge himself had at some stages complained against the Attorney General's department, asking whether he really was interested in prosecuting this matter or not? Was it just a matter of buying time and so throwing in the first charges that came? Is it a strategy that is used sometimes, or is it just a matter of the investigations having gone on and giving them the signal that perhaps really those were not the right charges to bring?
It could be both.
Okay.
And I'm being charitable because it's happened one too many a time when a nolle prosequi is entered. As far as, should I put it, sensational cases are involved. It's as if we rush to court, we prefer charges against a person, and then midstream we realize that maybe the charges are not well laid, and so we have to rewind back, do our homework well before we come up with what we think are the proper charges. If we have done our homework well and come up with what charges will be very well laid, then we will not need to always go in back and forth changing charge sheets and all that. So as I said, it could be both. Right. It could be that they realized that the investigation apparatus was not going to show up to the charges. It could also be a matter of buying time. Because if I enter a nolle prosequi, I withdraw the present charges, I substitute with fresh charges. Now, hey, the case is now beginning afresh. So give me a little time as far as this case is concerned. In the meanwhile, time is running out.
I see. Interesting. But you want to make a comment on that?
I think that coming from the ruling party, I beg to differ with Mr. Kisi, my good friend. If you put the Woyome case in perspective, you would realize that this case, as my friend would want to describe it, I mean, it's a case which came with a lot of sensation. Now, the state had to continue to investigate further into the matter to see whether, I mean, it could prefer more charges against, you know, some former government officials. And so people were invited in and interrogated. At the end of the day, it dawned on the Attorney General that the proper step to take was to enter the nolle prosequi. I mean, you see, this is a matter which hasn't even commenced in earnest. Witnesses have not been called yet. And so to suggest that the nolle prosequi entered could be the ploy of the Attorney General to buy time may not necessarily be accurate, given the fact that the state, the prosecution, the trial proper, was yet to commence. Now, what has happened, I mean, by no, I mean, a stretch of imagination, can delay the trial. Rather, justice, in my opinion, has been administered to those who, in the estimation of the Attorney General, ought not to have been charged. They have been left off the hook for now. Who knows? It is possible the Attorney General could prefer, I mean, charges in the future against them. But for now, I believe justice has been done to those individuals. The state was not out there, I mean, on a witch hunt.
The state, referring particularly to Samuel Nekwe Tete.
That's right.
His wife Nekwe Tete.
Yes, and Paul Asimenu. Yes, they have been left off the hook for now.
Right.
In the interest of
on what he's saying. Okay.
If I could chip in, see, prosecution is what it is. Prosecution. It is not persecution. If your investigative apparatus has not come out with hardcore evidence with which you can lay serious charges against a person, why do it in the first place? It's as if we are charging the individual to appease the public. And then, as I said earlier, midstream, we realize that we don't even have the evidence to show up those charges. We withdraw the charges. What signal are you putting out there? Every time you charge someone, sometime later you withdraw the charges and substitute with fresh charges. If it is not buying time, then it means that, it's, as I said, it could be both. If it is not buying time, then it clearly is a question of we charging prematurely. If we are not charging prematurely, what else can it be? Buying time.
Well, you want to continue with your point?
Yes. As I indicated earlier, the case itself, I mean, has a checkered history.
Okay.
I mean, there are so many, I mean, facets, I mean, to this particular case, so to speak. You have the same matter, I mean, pending in the civil court. The state has taken certain steps to recover, I mean, money supposedly lost as a result of Woyome's conduct. Once again, charges were preferred against him and so on and so forth. So the point I am making is that in the course of prosecuting these cases, some new evidence may have come to the attention of the Attorney General, which then made it necessary or constrained him to enter the nolle prosequi in the interest of justice. As I said, the bottom line is that when you set out to prosecute as a state, I mean, you are not out there to secure convictions at all cost. The essence of prosecution is to ensure that justice is administered to everybody. So if the ends of justice will be served through the entry of a nolle prosequi so that appropriate charges are preferred against accused persons, so that at the end of the day, some injustice is not caused, or occasioned. You cannot say by any stretch of imagination that the entry of the nolle prosequi, is deployed to buy time.
I have two quick questions for both of you, and yours is to ask you whether perhaps there was a need to wait a while and be a bit more certain about what one was going to do. I mean, we'll be speaking to Obo soon. He was a prosecutor for some time. He was on the show some time ago by phone, and his view was that in all that he had done a lot of the time, he felt that in trying to appease the public and all that, we may rush, and then once we've done our work, there's a need, then we begin withdrawing. Don't you think that perhaps a little patience in the matter would have been better, and that it seems as if the public was appeased with this rush? My question to you is that why then do we even have nolle prosequi in there in the first place? What purpose does it serve for us to have that on our books? Isn't that to suggest that we definitely may, in the course of events and in the course of gathering evidence, find that some charges may be inappropriate or some may have to be changed and turned around and all that, and possibly to use some people even as prosecution witnesses, as he said, and all that? Those are the questions to both of you, and I'm sure I've turned the same coin for the two of you, and I'll begin with you.
Right. You see, it is for a very good reason why we have that leeway, the nolle prosequi leeway. It is a discretion open to the prosecutor.
I wish you could read it for us. I mean, one of you. The provision. This is section 64.
No, 54.
54. I don't know if, I mean, for the benefit of the viewers, sometimes the viewers like to feel like lawyers on occasion when they can.
In a criminal case and at any stage of a criminal case, before verdict or judgment, and in the case of preliminary proceedings before the district court, whether the accused has or has not been committed for trial, the Attorney General may enter a nolle prosequi, as stated in court or by informing the court in writing that the Republic does not intend to continue the proceedings. It's a rather long...
Is it in a criminal case?
In a criminal case. Of course, this is the criminal and other offences procedure.
Right.
Yeah. So there's a good reason for it. You see, the standard of proof, as required of the prosecution in criminal cases is very high, proof beyond a reasonable doubt.
Absolutely.
And you need, as I keep saying, solid evidence to match that up. Okay. At the beginning of a case, you may believe that you have the evidence to go on to prosecute a person. But mind you, at every stage in time, you are trying to prove the person's guilt, not on a balance of probabilities, but beyond a reasonable doubt.
Right.
Somewhere down the line, it may occur to you that the case is going terribly bad as far as the state is concerned, in which case you might want to throw in the towel. Okay. The discretion that is given to the Attorney General to prosecute, okay, translates to the discretion that is given to him to halt proceedings if things are not going as planned. Okay. But that discretion, James said something earlier that I disagree with. He said that the discretion cannot be questioned. Discretion must be exercised non-arbitrarily. If you are exercising your discretion arbitrarily, tied to the fact that you cannot use the prosecutorial powers of the state to persecute people, so that's as if you just throw in charges against a person hoping that it will stick. If it doesn't stick, you will go and throw in charges, the fresh charges against the person. What are you telling the individual involved? And as I said, if you begin with a case, okay, and you realize that you do not have the evidence to match up the standard of proof required in criminal cases, don't begin at all. That is why I said it appears we are trying to appease the public. And the last time I showed up here, I said that it's as if we charge people based on emotions and, unfortunately, journalistic reports rather than what the law actually says. So if the journalists are out there, excuse me, the media practitioners are out there on the radio or TV saying this person has done this person has done this, oh, you should be charged with this, you should be charged with that, and you are the Attorney General, and if you don't take if you are not cautious and you go and charge based on what the journalists are saying or what the public is saying, you might mischarge, and then down the line you realize that the charges are based on emotions rather than on the law. The reason why I'm saying that in this particular case, because I don't see the facts or the fresh evidence that have come up in this case that has made the state totally to make a U-turn in respect of the charges. For instance, if you take the first charges against him, conspiracy to commit this crime, this and that, the only thing really that has been added to this thing is causing financial loss to the state.
Right.
What facts or evidence is now available to the state that made it change and add causing financial loss to the state that was not available to the state initially? It does not seem to me that the state could not have charged him with these two offenses. I have some problems with the first charges though. I don't see anything that has come out or could have come out in this period of time that is so fundamentally different that we now have to charge him with defrauding by false pretenses and causing financial loss to the state. It's not there.
I heard what Kisi had to say and his views on the matter. I was also asking you basically about whether really we had needed to take a bit of time and all. What do you think?
Well, you see, our law requires that a suspect arrested must be taken to court within 48 hours or allowed to go. If you don't put the person before court within 48 hours, then you have no basis for keeping the person. Now, when Woyome and the others were arrested, it was very necessary that charges were preferred against them. Otherwise, they ought to have been left off the hook. Now, there was the danger or real likelihood that once they were arrested, some of them could possibly have absconded from the jurisdiction. So, in the circumstances, I think that it was proper that charges were preferred against them. Now, I believe our lawmakers clearly anticipated that, all these things may happen in the course of a trial, that even whilst the case is ongoing, new evidence may come to the attention of the prosecutor. Now, in the Woyome case, that was precisely what happened. For instance, it came to the state had clear evidence that Prosecution and Nekwe Tete and his spouse may have been complicit in one way or the other. And that cost the state, a colossal sum of money. So, in the circumstances, what did you expect the Attorney General to do? So, he prefers charges against them. And once fresh evidence came to his attention, he enters a nolle prosequi. And then the arrest of Woyome and fresh charges preferred. You have to remember that the former Attorney General was invited by the CID much later and interrogated. I don't know what evidence the state elicited from her. Could it be possible that after the state had listened to her, it came to the realization that it would be difficult to sustain the charges against Prosecution and Samuel Nekwe Tete? That's right. And so I think that in the circumstances, the entry of the nolle prosequi was not an attempt to buy time. It was an exercise of the discretion by the Attorney General in utmost good faith, in the interest of the people of Ghana.
Okay. Let's bring Augustine Obro, a former prosecutor, into the discussions. Good evening to you, Augustine. Hello, Augustine, can you hear me?
Yes, I can hear you.
All right, thank you very much for joining us tonight. Yeah, of course, we're basically discussing the new twists to the Woyome case. And as a former prosecutor, what do you make of today's events in court?
Yeah, well, if I'm right, I heard the Attorney General's Department entered the nolle prosequi and then later rearrested the accused persons again. I was a bit surprised because I did not see the need for the nolle prosequi. If they have gathered new evidence, they can just go and withdraw the charge sheet and replace it or substitute it with a new one. now that you have entered the nolle prosequi, it means the bail and everything that they did, including the bail, recognizance there, they have to do it again. They have to start it afresh. That is a significant. That is in fact the other side, which is not too good for the accused persons, because now they have to apply for bail again. Everything about the old charge sheet is gone. So if they wanted to, if they found fresh evidence, which means that they have to change the charge sheet, they can only come, or they could have come, or they could have gone to the court to substitute the charge sheet with a fresh one, and the trial will proceed without necessarily asking for filing a nolle prosequi for the accused person to be discharged and then in a few minutes rearrested. I find it quite difficult to understand the bit of inconvenience to the accused person.
James Agalga, who is a lawyer, is in the studio with us, together with Kisia Jabeng, another lawyer and lecturer at the Faculty of Law. And James Agalga actually seems to be disagreeing with your foregoing points. Let's hear what he has to say. I saw you shaking your head vigorously.
Yes. I think that my learned friend Obo may have gotten it all wrong, particularly on the issue of the entry of nolle prosequi. You see, we have to understand that there was a charge of conspiracy. Now, if there was a charge of conspiracy and the Attorney General felt that, it was no longer necessary to have some of the accused persons remain on the charge sheet, or he came to the realization that there was the need for him to use some of the accused persons as prosecution witnesses, a mere substitution of the charge sheet would not be sufficient to enable him do that. Because if you substitute the charge sheet, you can't leave out others. You can only leave others off the hook if you enter a nolle prosequi. In this case, I believe because there was this charge of conspiracy which had to be established against all those who came together and conspired to defraud the state by false pretenses, that informed the decision of the Attorney General.
Your point is that a conspiracy charge cannot be brought against one person.
That's right.
Like a person must conspire with another.
Precisely. Now, I'll just give you an example. I was in this case of the Republic versus Dawson and others. It had something to do with the 77 parcels of cocaine.
Right.
Now, the state started the prosecution of that case, all right. But at some point, the state came to the realization that it needed to use some of the accused persons who were on board the MV Benjamin ship as prosecution witnesses. So they simply invoked the same process and used one of the accused persons as a prosecution witness. The point I'm making is that, in this given case, it is possible. There is the real likelihood that the Attorney General intends to use some of the accused persons as prosecution witnesses.
Okay.
So that entering the nolle prosequi, the substitution of the charge sheet would mean that all the accused persons would remain on the charge sheet.
Okay. All right. Interesting. Kisi, you want to chip in on that? And Auguste, hold on for me. I'll come back to you.
Seriously, there's much ado about nothing. As I said earlier, it is really a matter of style. Okay. There's much ado about nothing. Whether the charges were substituted or nolle prosequi was entered, I have a problem with the way it was entered. Not really about whether the charge should have been substituted or whether nolle prosequi should have been entered, because I don't see anything that prevents the anything in the law which prevents Attorney General from entering a nolle prosequi.
Okay. Yeah. But is there anything that prevents him from just substituting?
No.
So you go
I don't see anything. If I'm dropping charges against someone, I drop the charge. I drop the charges against someone, or I drop a particular charge against one and substitute for another charge. I don't see anything wrong with it.
I see. So in that case,
if I'm bringing back a charge of conspiracy, if I'm bringing back a charge of conspiracy against only one person, it is also possible. It is possible because you can charge someone. You can charge two or more persons should have conspired. That doesn't mean that one person cannot be charged with the conspiracy, especially if one person is on the run. If someone is on the run and we can't find him, we can still charge you with a conspiracy.
But in that situation, that person on the run will still have his name on the sheet.
Yes, we have his name on the sheet. That doesn't mean that sometimes the person may not even be known.
Okay.
If the person is not known, it's a John Doe.
Okay.
What do you do then? Because you don't know the other person, we don't charge you. Yes. So as I'm saying, I don't really see what this fuss is about.
Okay.
As to whether the charge should have been substituted or whether a nolle processor should have been entered.
Okay, Augustine, let me move you on to another point at this stage and ask you, because remember the last time we did a discussion, you were saying that perhaps we were also trying to please the public and that we needed investigations take a long time. You told us about the difficulties of doing investigations and that how much time is required in these matters. Do you think that it is only fit and proper right now to say that the AG has now perhaps found a sufficient grounds on which to proceed in this case, and that what happened earlier on was just a matter of, as Agaga has said earlier on, perhaps just making sure that some charges were brought which was required before moving on?
With the Attorney General, the power to prosecute is with them. So if they believe they've got enough evidence by now, well, they can come to court and prosecute the case. Initially, I told you what happened was the reverse of the whole thing. The case starts from police station to court, and then the case starts from police station to Attorney General to court. But what happened earlier on was from police station to court, and then back to Attorney General. So the whole thing was more or less something contrary to the norm.
Right.
So now maybe they finish their investigation, they've gathered enough evidence, and then they want to go ahead and prosecute the case. It doesn't necessarily call for a nolle prosequi. Nolle prosequi in prosecution in criminal law, we call it AK-47. You don't go to a disco with AK-47. It's just a pistol. That is a substitution. Nolle prosequi is too big to be playing with, like the way we hear of it these days in court. It doesn't go that way. If you ask the senior prosecutor, the experience, nolle prosequi is not that common. If you want to drop charges against A, you just file a new charge. You tell the court you are withdrawing the old one. The new one will exclude the name. Once you are withdrawing the old one, the court will still discharge the accused person. It doesn't call for nolle prosequi, which is too big. And it has a lot of inconvenience against the accused person. The whole bill is gone. They have to start it again. But they can, whether you want to drop charges or you want to add accused persons, you just add it to the new charge. Whatever you want to do, you add it to the new charge and you file the new charge. If you have to take the plea of the new ones you have added again, you take the plea again. If they have to recall witnesses we have called already, they have to recall them. It has nothing to do with nolle prosequi. Nolle prosequi is not used that way. You have to go straight. They could drop charges, they could add on charges to a new accused person could be brought on board, old accused person could be discharged and then used as witnesses. It doesn't call for nolle prosequi. Nolle prosequi is too big. And it has a lot of inconvenience against the accused persons, especially when they have to go through the bail process again.
What do you make of the charges that were dropped? The fact that 3 of the accused have been discharged, and also the current charges of defrauding by false pretenses and also causing financial loss to the state.
Who are the new accused persons who have been discharged?
No, I didn't say new accused persons. I'm saying that you know that the Nekwitetes, Mr. and Mrs. and also Mr. Paul Asimenu, together with Alfred Woyome were together in the first time around.
Yes.
And I'm saying that after the discharge today, after the nolle prosequi was entered, it was only Alfred Woyome who was rearrested. We are told so far. I mean, we don't have nothing has happened in respect of the other 3. So as it's where they have been discharged right now, we have 2 new charges against Alfred Woyome. We are told 2 counts as it were, defrauding by false pretense and also causing financial loss to the state. What does that mean to you as a prosecutor, and the style adopted, the fact that the conspiracy etc. is gone, the fact that the Nekwitetes and Paul Asimenu are no more there, and it's just Alfred Woyome at this stage?
It is very simple. If they have brought a fresh charge of fraud by false pretend, it means, in a very simple term, that Mr. Woyome or that accused person has made some statement which he knew was not true at the time he made it, as a result of which some state funds have come to his possession. It is just like what happened to Mr. Victor Solomon when he made a representation, when he caused money to be paid to Dr. Ozubodu, that Dr. Ozubodu had conducted some consultancy services, when in fact no such consultancy services had been performed. That was why he was convicted and sentenced to a jail term of 8 years. You see, so once they have charged him with fraud by false pretense, that is the verdict. That's what they are telling Mr. Woyome. I'm now hearing this for the first time. The whole they have been out of the radio and this. So that's exactly what they are expecting they are telling Mr. Woyome, that he has made some statement to somebody or a state institution which is keeping government funds, and because of that statement, which was not true, the state institution parted with some money to him. This is a very serious matter. When they charge you with fraud by false pretense, then you have to check what you have put on paper, what you have said somewhere. If it happens that you said that to collect some money, what you said was as a result of which the money was given to you, then you are going to be hot. But that's exactly what happened to Mr. Solomon. When the court, when he had to bring on board, when he had to bring into the evidence documents showing that Dr. Boyd had performed 80 such consultancy services, and he could not. So if the whole thing is about fraud by false pretense against Mr. Woyome, then Mr. Woyome is expected to show, after the prosecution has established a case against him, that a statement he made as a result of which money was paid to him was correct. And he knew it was correct and he believed it. But it turned out that money was paid to him as a result of a statement he made which was not correct, and he knew it was not correct, then he must be getting ready for trouble. That is what he has said. That's what the prosecutors are telling him and the whole world now. Okay. And those of us who understand the charge, that is what it means now.
Okay. Let me ask Kisio Jabe in the studio what he makes of these two new charges and the fact that the other two are gone.
Woyome becomes a fall guy. If you drop the conspiracy charges, you're saying that he did this thing alone. And so no one, that's the conspiracy and the accessorial charges.
Right.
So clearly, the prosecution is putting it out there that he was not in cahoots with anyone. He takes the blame. I see the problem I have with that charge, defrauding by false pretense, is that there is this very little thing which is problematic. It is called the element of inducement. The person who is being defrauded must have been induced by your false statement which was intended to defraud him.
Right.
It does not apply where the person who you were alleged to have defrauded knew that what you were saying was a false statement. Why am I saying that? Who is he alleged to have defrauded? The state. If what the facts, the so-called facts that we have now, of course, I have every I decry it being termed as facts because they've not been proved. But what the prosecution intends to prove is that he made some statement to the state officials which was false, which he knew to have been false, or was reckless as to whether it was true or not, whether he intended to defraud the state. That's what the charge is about. But what if the state officials, from what we know right now, actually knew that indeed he did not have a contract with the state? Is there an element of inducement? I'm not trying to prejudge the case, but that's why I said earlier that I have a problem with this charge. A very serious problem. If you can't show that there was an element of inducement, there's a case like that. There was this Lebanese, gentleman was supposed to order food on behalf of the University of Ghana from them. On the local purchase order, there was 10 bags of rice. He entered it at 110 bags of rice. He took it to the Lebanese. The Lebanese saw that really it was 10 bags and he adopted it to 110. They still issued him with supplied him the 110 bags of rice, turned around to the police station, and in court it was said that, look, you knew that his statement was false, you still went ahead. So if it is established, if I were one of his lawyers, if I will fight it to the point that it will be established that the state knew, or the state officials knew, that he did not have a contract, and they still went ahead to pay. If that is established, the case is gone.
Richard Keyamwa says it's a hoax. This case is going nowhere. June 12, we will see the state prosecutors begging for more time, and the courts will have no option than slapping Ghana with another cost of 2,000 Ghana cedis. Mark my words. Freddie Al, if Kennedy Japan is jailed, then Woyome can be jailed. Nutepe, CK Atipo, we live to see what the state can do. God bless Ghana. Bansa W. Oscar, how long did the trial of Chachu last? So why this rush? Issa Hayatu, I think they are afraid to lose, and the way things are going, they will surely lose because administration has never ever won a case at the law courts before. Patrick Noble, Ifa, Ghana is no more. Dude, Jibe, Z, Way, Xwell, maybe that is their prosecution strategy. If they themselves fire and also make rearrests, it's their own cup of tea. Ghanaians are better judges come December 7. God help Ghana. Upon Yabua, it is my prayer that the NPP wins 2012 and fairly takes on this Woyome case, because the Mills-led government wants to throw dust into the eyes of Ghanaians by delaying justice in this case. Ghanaians beware. Bansa Oscar again says the NPP were never even able to jail Nana Konedo after that long trial. They should give us a break. Bourgeoisie Bernard Moro says, I love you, Gagantuan Woyome. I need a dosam. Alright. Merlin, some comic relief sometimes really does help. Merlin K. Williams says, in fact, God will punish Ghanaian leaders from up to down. How can Woyome carry 510 billion cedis? Meanwhile, Ghana borrows from our sister nations. If Woyome should be set free, God, I'm a sinner, but don't swear Ghanaian leaders. Why corruption? People in villages need water, light, and clinics, and you Woyome alone. Okay, Citizen Mass says, if governments try to stretch this issue, Woyome will expose the NDC. Bansa Oscar again says, how many cases did the NPP win in less than 8 months? Nana Ado says, we are not talking about NPP and NDC, but rather money that we are supposed to use for the Better Ghana agenda. Bansa Oscar, fourth time, says, and has the NDC set Woyome free? No. Is it the NDC or you mean the courts? David K. and Hassan, fire burn all the leaders involved in this matter. Okay, all right, sounds right, Rastafari to me. Martin J. Wentefler says, why shouldn't Ghana take this huge money from him rather than this court thing? Okay. Atabata says, the other 3 persons are not left off the hook. They've just been discharged and not acquitted. They can be rearrested anytime or be invited as prosecution witnesses anytime state prosecutors deem it fit. Paul D. Oh, Ghana. That's all you say. Sapon Achampon says, I think the state will go ahead this time. They will not ask for more time. Nicholas Domanumbo, I am shocked, perplexed, dumbfounded, overwhelmed, flabbergasted. Simply put, I'm surprised. Is that how to simply put all that? Maybe I should send the government to court for some judgment debt too. Okay. Oh, Barlow loves MUFC. Says, I'm sure they don't want more bombs from Mr. Amido. Farouk Shaibu says, Woyome, Ghana, we need our money. Emmanuel Ndakofi says, what kind of country is this? Are we going or are we coming? Wow, that's a typical way of putting a Ghanaian. Says, which one? If the NDC think that they have not gotten the men to prosecute Woyome, then they should call the NPP to do it. Those are the messages that are coming in now. And basically, this is also tied to some discussion that we had on this show some time ago, where someone said perhaps we should be thinking of private prosecutors. And I actually discussed this with Obo on the line sometime. And he said the gentleman didn't know what he was talking about. But really, James, with all that we've been talking about, what we've been discussing since before we took our break, I'm sure you have some thoughts on the matter as well.
A lot has been said. My good friend Kisi has hit the nail on the head. I mean, with regards to what ingredients the prosecution should be looking out for.
Right.
I mean, in their quest to establish the guilt of Woyome beyond all reasonable doubt. I don't think I want to add to that.
Okay.
Having said that, I've listened to some of the text messages, and I think it's important that I react to some of the sentiments raised.
Right.
For instance, Woyome is alleged to have defrauded the state by false pretenses. We all know what efforts the NDC government has done, to try to recover the monies lost to the state. I think that what this government has done is unprecedented. Look, Woyome, yes, unprecedented, and I'm not ashamed to use that word. Woyome, look at the person called Woyome and who he represents. Woyome has been touted as a financier of the NDC. Now, the same Woyome is alleged to have defrauded the state by false pretenses. And what does the Attorney General's Department do? Have they left him off the hook? No. Contrary to some of the sentiments raised, I mean, in the text messages, the state has taken action in the civil court to recover the money. Woyome is also before the criminal court. If he's found guilty, he's going to serve a jail term for committing that crime. In addition to, I mean, the possible recovery of the money. What else do you expect from a responsible government other than the steps that the state has taken? I mean, we're all in this country. When I don't want to, cite examples, when others were confronted with similar, circumstances, they chickened out. They chickened out.
In which matter?
Also, so many examples. I mean, the Mukta Bamba and the like, all of them were accused. Similar allegations were leveled against them, but we saw how the government at the time reacted. Now, this government is saying that, look, we are not going to protect our own kind, regardless of who you are. I mean, if you have fallen foul of the law will take its course. But you see, we should be mindful that Woyome is a citizen of this country. I mean, his rights are guaranteed under the Constitution. And so this government would not violate those rights. Woyome has the right to a fair trial. We would not do anything as a party in government to prejudice or violate those rights to a fair trial, which is why, time without number, I have refrained from discussing the merits of that case. Okay. Let the judiciary deal with the matter, the way it should be dealt with. Okay. At the end of the day, justice is going to be done. That's the beauty, about our judicial system. There are so many checks and balances, So, for now, I think that it is premature for us to say the charges preferred against him is a hoax. It is an attempt to set him free. No. Nobody knows what evidence the state has. Let us all wait. When the prosecution witnesses go into the witness box and evidence is adduced, the people of this country would be in a better position to judge whether this government, left Woyome off the hook or brought him to the fountain of justice. All right,
Augustine, are you still there? I'm sure you are. Before we go, let me get your final thoughts on this matter, your concluding remarks as we move along with this. And as a prosecutor, I'm saying that as a former prosecutor, I'm sure you know how the mind of the AG's department will be working now. I want to get your final comments on this matter. What do you see going forward?
You see, my fear is that if the two other accused persons now who are discharged, if they are taken as public servants and the intention is to use them as prosecution witness, then I'll refer them to what happened in the case of the Republic versus Shariati. When we used a kingpin in that crime as a witness, we lost the case because that man had lost his credibility. So they should be very careful who they are going to select as a witness. Because if they should select people who were so much involved in the commission of the crime, then they will not have any credibility in the witness box. And that's what I'm referring to them. That is exactly what happened in the Republic versus Shariati. Our key witness had lost credibility when he was in the dock because he had participated seriously in the commission of the crime. So they should be very careful. Apart from that, if they have other witnesses who are genuine and did not partake in the crime knowingly, then certainly Mr. Woyome will have a serious, will have to give a very serious explanation to the court because his case falls squarely with that of Victor Solomon. If you read that, it's the same as that is what is being preferred against Mr. Woyome alone now. Because if you are charged with fraud by false pretense and the amount belongs to the state, automatically the offense of causing financial loss will be established. Because the money would have moved from government coffers to a private person, and the state would have lost it. That's very easy. Very, very easy to establish the second count. If that is the second count, I am not familiar with the charge.
Okay.
But that is exactly what is likely to happen.
All right.
Concerning the, but that is my fear about those who are suspecting that the NDC government might not be able to prosecute Woyome. But they should take politics out, because the prosecutors are professionals; they are not politicians.
Okay, but when you talk about people participating in the commission of the crime, you know, I mean, you say the commission of the crime. Doesn't at this stage are we able to really say that about them, that they have participated in the commission of any crime?
Yes, because if you see, my learned friend there said it. You know, this is not a crime that one person can commit. More especially when Mr. Woyome is not a public figure, or is not a let me say, public servant who wielded so much influence and authority in the, for instance, like a minister, so that he could order people to do this and they did. This is a private citizen who came in with this application or someone for judgment and those kind of things. So those who participate, those they are going to bring as witnesses, they must be genuine people. Otherwise, I can assure you, they will be discredited seriously. And I'll give an example. That's exactly what happened. I was among the prosecution. I was with the learned DPP when we prosecuted that case, the Republic versus Shariah. And that's exactly what happened to our key witness.
Okay. Thank you.
They bring out.
All right, Augustine, let me take the final comments from the two gentlemen in the studio. Let's begin with you, James.
Yes. A quick reaction to
if you can.
Yes, Augustine Obo has just said, look, in another, breath, in the Republic versus Dawson, the state entered the nolle prosequi against Nkum. Nkum was on board the MV Benjamin ship when it embarked upon that ill-fated voyage which brought into this country 77 parcels of cocaine. Now, when nolle prosequi was entered against him and he was subsequently used as a prosecution witness, the state secured convictions against all the accused persons except my client, the second accused person, Park Boxil. So you see, let us give the state the benefit of the doubt. The mere fact that Samuel Nekwe, Tete, Paul Asimenu were charged alongside Woyome and discharged does not necessarily mean that their credibility could be destroyed. It depends upon what evidence the state has that they can assist the state to adduce in the course of the trial.
Kissy, we'll take your concluding remarks.
See, the state has every right to prosecute a person. The state can arrest for any reason as long as it is within the bounds of the law. And my learned friend here said that the state has been given 48 hours to produce a person before court when arrested. It should tell us something. Before you arrest a person and put him before court, there must be a basis. We must treat ourselves civilly and according to what the Constitution prescribes. If you do not have any basis for arresting the person, within that 48 hours, you must produce him before court. If you're going to throw a charge and hope it will stick, and midway you realize that it's not going to stick, it does not augur well for the repute of our criminal jurisprudence and our criminal justice system. Once again, before you arrest someone and put him before court, there must be a basis. The Constitution does not allow for baseless charges and baseless arrests.
We have to end the show here, right here.